Welcome to Legal Views with your host, Attorney Sheila R. Stuart.
Thank you so much, Johnny and Daryl Breath. We are so excited to be here on today. Thank you for hosting this program for us, Legal Views with Attorney Sheila R. Stuart. We have a great guest for you on today, Bishop Attorney Melvin J. Smith, and he is going to share some valuable information with you on today. We are coming to you live on CJoy Network, Live 365, Facebook, and YouTube. So please subscribe to our YouTube page under Legal Views with Attorney Sheila R. Stuart, and you can follow us on Facebook at the Law Office of Sheila R. Stuart. Now, many people have been in various types of accidents. You've been injured, whether it's in a hospital, injury, whether it's a slip and fall on the job. And many of you have not had the representation that you need to succeed once these types of injuries and these types of complications come in your life. So you want to know how to handle various types of problems that you may get confronted with. And so on this program today, we're going to give you some solutions and some information that will assist you in working through most of these problems on today. And we have with us the one and only Bishop Melvin J. Smith. He is an attorney of over 30 plus years. He has practiced throughout the United States of America, and he has an office here located in St. Louis, Missouri. He has various TV shows where he provides valuable resources and information. Good evening, Attorney Bishop Melvin J. Smith. How are you today?
My friend, attorney, counselor at law, Sheila R. Stuart. All is well in my life. How about you and yours?
I am doing quite well on this evening, and I am so happy that you are with us today. And we're not going to do a lot of talking because I know people are tuning in so they can hear you. So before we get started, would you like to tell our listeners where you are located and your phone number?
Absolutely. I'm located in St. Louis, Missouri. The office where I primary practice is located at number 2 City Place, Creve Coeur, Missouri, 63141 Suite 200. And also I'll give you my church location. I walk in both location. I pastor the National Temple Church of God in Christ, which is located at 3300 Marshall, St. Louis, Missouri, 63141. But the best way to reach Melvin Smith is by calling me. I freely share my cell phone number with clients and with people. The best way to reach me is area code 314-805-3480. The best way to reach Melvin Smith is to call me at area code 314-805-3480.
Okay, great. Now you have this information if you're dealing with some personal injury matters, how to reach Attorney Melvin Smith. And I am located at 231 South Bemidji Avenue, Clayton, Missouri, Suite 800, 63105, if you are seeking any type of employment information. So let's get started. Can you tell our audience the type of personal injury cases that you actually handle?
So I'll be happy to, but also before I start, Attorney Stuart, and before I forget, I do want to thank you and appreciate you for this opportunity to come and speak and to, it's my honor to be with you. I've known you for a number of years. You are an excellent member of the bar, and we are so gladly proud also to have you as a faithful member of the church where I serve. So having said that, personal injury is a very fascinating area of the law. In terms of personal injury, I represent people who have suffered injury as a result of the negligence of other people. That negligence may be in the area of somebody who runs into you with their vehicles. So we handle personal injury cases, including automobile accidents. We handle workers' compensation claims. That's when you're injured within the scope and course of your employment. In addition to that, we also handle quite a few of medical malpractice or medical neglect cases against healthcare providers, whether it's doctors or hospitals, whatever the case might be. Just think in terms of anytime there's injury done to the human body as a result of carelessness or negligence of someone else, we handle those type of cases. It may be what we call premise liability. That's just a fancy way of saying that you're at one of the local establishment and the floor is wet and it should not be, and you slip and fall, or if you're out and someone is not properly maintaining their dog and you suffer dog bites. We handle cases of various types when there are injuries to your body.
Oh, very good. Very good. Now, as you know, there are some big law firms out here today. I won't call any of their names and give them any free advertisement, but there are some very big law firms out here today that handle personal injury cases. Why is it why do you think it's very beneficial for a person to select your office over one of the larger law firms?
That's an excellent question, and I thank you for that opportunity, because personal injury, there are a lot of people who handle personal injury cases. There are people who handle personal injury cases in addition to this case and that case and that case. One of the main reasons you want to contact my office is 99% of the cases, well, 90% of the cases we handle are simply personal injury cases. That means that that's what we're set up to do. We've been doing it for over 30 years. I said 90% because as a pastor, we do pro bono and work for churches and things of that nature. But the reason you want to call the law office of Melvin J. Smith and Associates, and I actually use this in my advertising, Attorney Stuart, I often say, don't delay, call me today. And sometimes when people hear that on television or radio, they pick up the phone and they call me. And when I pick up the phone, they say, wow, it's really you. So the point I'm making that story is that you can call some of my competitors that are larger than us. But unlike them, the man that you see on the television or the man you hear on the radio, when you call my office, you will speak directly to me. I'm what you call a boutique law firm. Okay. In other words, I like to talk to my clients, and I'm very hands-on. And I promise you, at some point at the beginning of your case, you're going to talk to Melvin Smith. It's my name that's on the door. I'm the one that advertised. I've been doing this for 30 plus years. Just think about it. When you call a lawyer and you've been injured in an automobile accident, do you want to talk to somebody who is a first-year associate right out of law school that just passed the bar? Or do you want to talk to Melvin Smith, who's been doing these cases 30 plus years?
They want to talk to you.
Absolutely.
Now, what motivated you to assist people that have suffered various injuries? What's your motivation?
That's a good question. I started to practice in the area of personal injury because as I opened my law career, I started to see people that were injured. I'm talking people who suffered life-changing injuries. Wow. And unfortunately, the type of care and treatment their cases needed, I just didn't see lawyers doing that. I wanted to be able to help people that was there. They're suffering in agony. I want to be able to give them the hands-on attention that they need. The other thing that I love about the area of law that I practice is One of the greatest injustice, I believe, Attorney Stuart, in our legal system is, unfortunately, people don't always have the resources to pay for what they need. When it comes to personal injury law, we work on what's called a contingency basis. That's just a fancy way of saying, if I don't get you fair and just compensation, you don't owe me anything. Okay. So as a personal injury lawyer, people are able to hire me and retain me, and there's no money out of their pocket. Typically, you almost have to bring a lawyer a week's salary or several $100s just to sit down and talk with that lawyer. But the cases that I handle, personal injury, there are no upfront expenses. You don't owe me anything. And without what we call the contingency fee, most everyday people like you and I would never even be able to have their day in court.
Okay. And that's very important, that the justice system allow all individuals to have an opportunity of justice, not just those with money and those that have name recognition, but all individuals that have suffered any form of injustice, that they can contact an attorney knowing that, hey, I don't have any money, but my case is going to be put forth and it's going to get promoted. Now let's talk about the types of personal injury cases, because lots of times people believe that if they have suffered an injury, a broken bone, a broken back, or some serious injury like that, that is the only time that they can go and seek out legal intervention for those claims. Can you share with us the whole ideology behind soft tissue damages, a sprain, and those types of things that are actually profitable for individuals that have been injured?
One of the things that I often explain to people sometimes think, well, because they're an offender bender and they may not have a herniated disc or a ruptured disc, or it may not be a torn ligament, or you don't tear your ACL, that they were not injured. Soft tissue injury is still an injury. Thanks be unto God that you didn't have to spend a week in operations or a hospital. But anytime you're involved in an auto accident, I often recommend you go to the doctor, go to the ER room, and let them look you over from head to toe. And oftentimes the ER doctor will say, well, ma'am, there's nothing broken, or sir, we're glad that there was no fracture, but you have what's called a sprain strain. That's commonly what we refer to as soft tissue injuries. And let me caution those that are listening, because the first thing the insurance companies would say, I've been fighting with them for 30 plus years, is that, well, you weren't injured because you were able to walk away from the scene of the accident, but there is something that's called soft tissue injury. So anytime you have pain and aches and you feel things that were not there before the accident, or there was things there and they've made worse, don't minimize injuries just because they're what we call soft tissue injuries. Here's another area where often I see insurance companies and adjuster attacking people that have been injured. They will say, well, there was no damage due to your vehicle. There was no damage done to your vehicle, or just barely damage done to your vehicle. Same thing applies. There's a tremendous difference between what a two-ton automobile can withstand versus what the human body can withstand.
Absolutely.
So there again, I always say, get yourself checked out, go to the ER room, go to your doctor.
Very good. Now, as you know, we're still in this COVID area. COVID is still prevalent. Many people have been vaccinated. Then we have a large population that still have not been vaccinated. Can you tell us, this is kind of like a three-part question. So I had to give you the first part.
Thank you.
The first part is, tell us how a workers' comp compensation claim works. Okay. How
Okay.
if a person has been injured on the job, tell us how that type of claim works. Number two, can a person file a workers' comp claim if they have been infected with COVID-19 on the job? Can they file a workers' comp claim if they have been infected with COVID-19 on the job? And then give us the overall, understanding of how workers' comp claims work.
Thank you. Workers' compensation is a very fascinating area of the law. So just think in terms of workers' comp. The law says that if you're injured within the scope and course of your employment, you're entitled to benefits. In other words, if you're injured within the scope and course of your employment, you fall under, I'm in Missouri right now, you fall under the Missouri Workers' Compensation statute. Most states are the same. Now, the first thing I want you to take from that definition is within the scope and course of your employment. People erroneously think that you have to be at work to be compensated under the workers' compensation statute. Okay. Oftentimes, your employer or your manager would tell you, you don't get workers' compensation because you were driving in the streets and you were not here in the plant. No, I've represented people who were traveling in New York. They were injured in New York, but they worked in Missouri, but they were traveling on business, which means that you're entitled to workers' compensation. Think about workers' compensation. You're doing something that is going to assist your employer to make money. And as a result of that, you suffer injury. Mm-hmm. So the law says that you're entitled to workers' compensation benefits. Those benefits usually come in about three areas. One, you're entitled to medical treatment. They're not, sometimes people call me and say, Attorney Smith, I don't think I need a workers' comp lawyer because they're already paying for my medical bills. They're not doing that to be nice. The law is that if you're injured within the scope and course of your employment, legally, your employer must pay for your medical bills. So you're entitled to have your medical expenses paid. Secondly, if the company doctor certifies that you need to be off from work, and in Missouri, you're off from working for 3 days or more, mm-hmm. you're entitled to temporary benefits. Now, that can take a whole show by itself, because sometimes I've seen people injured on a job and they have to use their sick time, vacation time, comp mm-hmm. time. No, you're entitled to what we call TTD. And then the area that they will never tell you about is that as a result of the injury, if you suffer permanent total or permanent temporary disability, you're entitled to a lump sum payment of several thousands of dollars because of your work-related injury. Now, let me try to tie that in with what's the hot topic for this day and time, the coronavirus, mm-hmm. COVID-19. Number one, I do represent people at my office who were at work and within the scope and course of their employment, they contracted the virus. So mm-hmm. I do want you to know that the law is that if you're within the scope and course of your environment and you contract the coronavirus, theoretically, you can be compensated. Okay. Now, let me also openly confess that we're facing what's called a case of first impression in a lot of these scenarios. And that's just a fancy way of saying a lot of these cases dealing with work-related injury and the coronavirus are new and we're seeing them for the first time. But I would encourage anyone who believes that he or she was at work or within the scope of your employment and you contracted the coronavirus, call a lawyer. Now, this is very important. Write it down. Make sure you call an attorney who is experienced in handling work-related injuries. And that's important because if you call someone who does not have that kind of understanding, I promise you, those lawyers often will simply tell you, everybody's getting the coronavirus. How can you prove that it happened at work? The thing I always tell my client, that's my job. You let me deal with what we call in the eyes of the law causation. But make the phone call, because the law is that if we can prove or show, or by the prevailing evidence or prevailing factor, is that your job contributed to your work-related injury, and now you have the coronavirus, you may very well be entitled to be compensated.
Now, let me jump in for a second. And I won't call the name of any of these companies, but some companies that have close work environment where individuals cannot properly social distance. And some individuals, as you know, refuse to wear the mask. They're not wearing a mask, and they're not able to social distance. I believe that these are cases where the facts support a workers' comp claim if an individual contracts COVID-19 on the job. What are your thoughts on this?
My position, call me, don't delay. As I said, if you don't have an experienced workers' compensation lawyer, the first thing the employer or the insurance, I shouldn't say the employer, because 90% of the time it's the insurance company or their insurance company lawyer that I'm going back and forth with. The first thing they're going to say is that, how can we prove that you contracted it here on the job? Other people have been coming to work and they have not contracted it. There again, that's why I emphasize you contact, I prefer you call attorney Melvin Smith. Mm-hmm. However, if it's not me, make sure it's someone who has handled workers' compensation cases. The other thing to bear in mind is that 75% of the cases that are initially filed under workers' compensation are denied, maybe even more.
Wow.
The insurance company, my colleagues are going to talk about me on Monday for this one. There's a form letter in the database of a lot of insurance company and defense law firm that the moment they get a report of injury, they hit a button, it produces a form letter. The form letter says denied. Wow. Don't have enough information. That's the way it just operates. But just because they don't see it doesn't mean that it did not happen within the scope and course of your employment.
So why do you think so many claims are automatically denied and people are actually injured? Is it the causation issue?
That's a good reason. And fair, let me try to be fair. And the reason I often have to be careful what I say when it comes to social media, and as you know, we're on television, it's because I often get calls from my friends that are on the other side defending these cases and say, Melvin, you were not fair. So let me try to be fair. There are some people out there that file claims that are not entitled to be compensated. Okay, that happens. And what I often say to defense lawyers, this might sound a little crazy, but I often say to the defense lawyer, if you think that this person is not entitled to it, or there's something funny or creepy about this case, or if someone came to my office and they did something and they're faking whatever, I tell defense lawyers, show me what you got. Mm-hmm. You know, if you have a videotape, send me the videotape. I'll sit down and happily meet with those individuals, because I don't want to represent people who are faking injuries. You know, there are people out there with serious permanent injuries. There are people out there with soft tissue injuries, nonetheless, injuries. But the reason insurance companies deny claims so much, you asked the question, so I'm going to answer. Usually it's cheaper for them not to pay out on a claim than to pay on a claim. Let me say that again. They make a business decision. It's cheaper for them not to pay than for them to pay. So if they say denied and you go away, they've just saved the insurance company money on a claim.
So you're hearing this live on Legal Views with attorney Sheila R. Stuart. That means you have to have someone that is knowledgeable of the system and that is prepared to fight on your behalf, because 90+%, 75% of these claims will get denied. And if you have an attorney that is prepared to go in and to fight for that injury that you have received, you are more than likely to come out a winner. Now, you had made a statement previously as it relates to workers' comp about this lump sum of money a person can get for this total body injury. Can you elaborate in more detail on what that consists of?
Sure. We know, and research shows, that once there's injury to the human body, your body never goes back to being 100% the way it was prior to that injury. That's research, that's medicine. The body never goes back to being 100% the way it was. You may get to 90%. You may get to the point that the injury is not as noticeable as it was upon the date when it happened. But the law says because your body does not go back to being 100%, that's what's called permanent temporary disability or permanent partial. Not saying that you can't do anything, but you may not be able to do everything that you used to do. So under Missouri workers' compensation, because of that, the law says that we can't heal you 100%, but in order to make you somewhat whole, we're going to compensate you with money. Now, that's in the area of workers' compensation. That's what we, for lack of better comparison, that's what we call damages. People tend to be more familiar with the concept of damages when it comes to other type of personal injury cases. For example, automobile accident, where you're entitled to pain and suffering. Damages may be the medical expenses that you pay out of your pocket. But under workers' compensation, we help compensate people for that lump sum percentage, that lump sum payment for what we call permanent partial disability, or in some cases, the injury may be so severe that the individual cannot go back to doing the type of work or work as they were doing.
Wow, that's very interesting. I wasn't aware of that lump sum payment that many individuals can receive. Now, is it difficult for an individual to obtain that type of payout? Is that difficult as well?
You have to prove the case. Difficult. If you know what you're doing, you've been doing work in that area, you can present evidence to the satisfaction of the defense lawyer, or more importantly, to the administrative law judge, to be able to substantiate that there is a permanent partial or permanent total disability. But it can be proven. You know, if you know, you have to be able to get the documentation of it, whether it's having the individual be seen by an expert that can give you a medical opinion that John Doe may have 10% permanent disability or permanent partial disability. It can be proven, but you have to know the area of the law.
Okay, very good. Very good. Now let's shift a little bit here and let's discuss medical malpractice. Medical malpractice claims are very difficult to prove. If individuals think that they have a hard way to go with workers' comp, I believe that it's even more exacerbated with a medical mal claim. And they have to get these cases certified by a doctor to show that that there was some form or level of negligence. Can you just give us an overview of how a medical malpractice case would work and what it would take to move a medical malpractice file forward?
Attorney Stuart, this is going to sound a little strange.
Mm-hmm.
Probably for every 20 calls I get
Mm-hmm.
for representation regarding medical malpractice, out 20 calls I get, I may take one of those cases.
Okay.
Medical malpractice cases are very challenging cases. And I often tell people, you really don't want to have a good medical malpractice case. Right. And that usually catch people by surprise. I've been doing this 30 years, so I can say it this way now. When I first started to practice law, I wouldn't say this. But I tell people, you really don't want to have a good medical malpractice case. Because if you have the type of medical malpractice case that most lawyers will accept, who knows what he or she is doing, mm-hmm. that means that you have some type of a permanent, ongoing injury, or it's so permanent that it may result in death. Mm-hmm. So I often tell people, you really don't want to have. I get people call me and say, I have a good medical malpractice case. And I ask them things like, are you able to walk? Yes. Are you able to talk? Yes. Are you able to do all of the things that you were able to do prior to the incident? Yes. And I said, well, you really want to talk to Pastor Melvin Smith and start praising the Lord right now. And the reason I say that, let me put my serious hat back on. The reason I say that is that when it comes to medical malpractice case, the law requires two things. One, you need to have what we call an act of negligence. Negligence means that a doctor or a healthcare provider failed to do something that reasonable doctors would have done. They failed to do something, or they did something. Now, that's step one. Mm-hmm. Then step two is that that negligence must have resulted in some type of permanent or ongoing life-altering injury. Because otherwise, these cases are so expensive, yes. They're so time-consuming that it would almost cost a law firm and cost a client more money to pursue the case than they would receive from a jury. Also, as you mentioned the word certified. Mm-hmm. The law in the state of Missouri is that before we can really file these lawsuits when it comes to medical malpractice, we must have an affidavit from a board certified doctor that in his or her opinion, and here's the key, based upon a reasonable degree of medical certainty, whatever that means, that's the legal definition. Mm-hmm. Based upon a reasonable degree of medical certainty, in my opinion, this is a case that should be pursued because there's medical malpractice. So they're difficult cases. That's not to say that they don't exist. They do exist. I just accepted one last week. And in that case, here's what I'm referring to. In that case, the doctor did not do what he should have done. And some of the afterbirth was left in a young mother. Okay. And the doctor failed to do what he should have done. She went back complaining. Mm-hmm. And the worst thing that could happen to a lady that's in her early stage of childbearing is that she had to have a total hysterectomy. Now, that's a pretty severe injury.
Yes, okay. It is.
But the point that I'm making is that when it comes to medical malpractice cases, they're very time consuming. They are expensive. So when you hear from a lawyer that, it's not a good medical malpractice case, those are some of the reasons that he or she really should share with you.
And what would you say the cost is to work up a medical malpractice file? Would you say it's around $100,000?
You know what? Those cases, and not just medical malpractice cases, it's litigation, period. Mm-hmm. Okay. When it comes to litigation and we, medical malpractice cases, even one that you find out at the end of the day, those cases, Attorney Stuart, you can invest 20, 30, you can really spend six figures $100,000 just to properly prepare a case. Because when it comes to litigation, I can't just show up, judge. It's neglect, it's malpractice. I have to be able to retain the expert witness. Mm-hmm. You know, you assisted me in a case a few years ago, and if you just remember that case that you did such an excellent job, you had to fly out to New York on that case. You had to stay in a hotel. We had to invest in engineers, and these people don't work for free. Right. So medical malpractice cases and personal injury cases, depending on the issues involved, they can run six figures in terms of the cost of litigation. Yes.
Yeah. So individuals, I know individuals have called me for medical malpractice, and I just refer those cases out because I know it's extremely expensive. And then, like I share with people all the time, I mean, your injuries have to be so significant that you don't want to even have to file a case like this. Have they cut off the wrong leg and those kind of things. Those are the cases that many attorneys would want. But if the injuries are not significant, you may just not need to file that case. Now, what about filing a medical malpractice case as it relates with a health provider?
Now, when it comes to health provider, those cases, health provider basically mean anyone who renders medical treatment, mm-hmm. doctors, nurses, hospital, clinics. So those are the type of individuals or entities we refer to when we say healthcare providers. Let me make one other point regarding medical malpractice cases and workers' compensation cases and automobile cases. One of the biggest areas I see when it comes to people not being successful in personal injury cases, whether it's medical malpractice, workers' compensation, automobile accident, and I'm sure even in the type of cases you handle, Attorney Stuart, it's delay. Delay is not your friend. In the state of Missouri, when it comes to a medical malpractice case, there's what we call a 2-year statute of limitation. That means that if that case is not filed in court within 2 years, that's it. There are a few exceptions, not worth talking about. When it comes to Missouri workers' compensation law, there again, if that claim is not filed, you have a 2-year statute of limitation, either from the date of the injury or the date of treatment, and that gets all fuzzy. But then when it comes to automobile accident in Missouri, you have a 5-year statute of limitation. You can file it in court up to 5 years. But then on the other hand, if your accident is just on the other side of the river in Illinois, for a car accident, you have a 2-year statute of limitation. So even sometimes as lawyers, we have to sit down and pay these statute of limitations great attention. So the point that I make is that if you think that you have suffered injury and you're entitled to be compensated, delay is not your friend. I encourage you to talk to a lawyer as soon as possible, have him or her investigate and research and help you to decide whether or not this is something that you really want to pursue.
Okay. Can you explain to us about caps, financial monetary caps that have been placed on many of these worker comp claims and so forth? I know, like in employment law, there are financial caps that have been placed on employment claims. They filed new legislature in 2017 as it relates to how many employees you have and so forth. So there are financial monetary caps. Can you tell us about the monetary caps that are placed on some of the workers' comp claims?
Caps can come in various form. Oftentimes, when it comes to damages in the area of injury cases, in some cases they may cap your damage for what we call emotional or pain and those type of things, or non specials. they may cap them at, or let me backtrack. The cap for pain and suffering may be $250,000 in some scenario. There are times when I see caps when it comes to what we call policy limits. And that's something that everyone should take a look at. For example, let's say when it comes to your automobile policy, your policy limit may be $25,000 per person, $50,000 for the whole incident. And you can try a case all year long. And let's say theoretically, if a jury awards you $100 million, but the policy limit says $25,000 per individual, then that's really the amount that an insurance company legally has to pay. Now, there are some people and they call me and, sometimes they like what I say and sometimes they don't. They say, well, I want to go to court and a jury will give me more. Well, sometimes if you can get the policy limit versus spend thousands and thousands of dollars and weeks and months and years, and you're still not going to get more by way of compensation, it's probably best to take the policy limit. Even when it comes to the workers' compensation cases, there are areas where the law says that you're only going to get X amount. There's some things I love about workers' compensation cases, and then there's some things I don't like. One of the best things I love about workers' compensation cases is that I just have to prove that someone was injured within the scope and course of their employment, and I can get them compensated. But then it's limited based upon a mathematical formula that we have to use. And unfortunately or fortunately, a part of that formula is the amount of money you make on a weekly basis. So there are caps and limits all over the legal world.
Very good. That's excellent information. You are listening to Legal Views with attorney Sheila R. Stuart. We have with us as our special guest on today, Bishop Attorney Melvin J. Smith, and he is sharing some very critical information as it relates to bodily injuries, personal injuries, workers' comp, your rights for workers' compensation if you have contracted COVID-19, as well as the steps and the information that will prove to be very helpful in a medical malpractice claim. As you can see, you can contact attorney Melvin J. Smith at the number that's listed below the screen. We have it scrolling throughout this show. Contact him for your personal injury claims. Now, you are also a pastor.
Yes, ma'am.
During the COVID-19 season, many pastors filed insurance claims. They filed many insurance claims in order to get compensation for the loss of in-person services, the offerings, the activities that they were involved in. And many of these individuals use what we would call the business interruption rule to substantiate their right for payment. Many of those claims, or most of those claims, were denied. Can you share with us some information as it relates to moving a claim for compensation, an insurance claim, and what they should look for on those policies in order to get compensated?
I think everyone who has an insurance policy, whether it's auto, whether it's health, whether it's business, whether it's homeowner, the first thing that you have to do is sit down and read that policy. Because I've represented people in the religious community, I've represented people in personal injury cases, and they thought they had one thing under their policy, and it just did not exist. Mm-hmm. When the pandemic hit, when this pandemic hit, a lot of churches and businesses and grocery stores and restaurants had an interruption in their business. Mm-hmm. There is a provision under a lot of policies that deals with what we call business interruption. In other words, there's an interruption in your business. And a lot of us thought that we had that coverage. But what these insurance companies have done is that they have specifically excluded things such as virus or pandemic when they shut down your business. So yes, your business has been interrupted, but then you have to look at the reason that the business was interrupted. For example, God forbid, but let's just say a tree fell on the church and now you can't have service. It's not because of the virus or COVID-19. Your business have been interrupted by an act of God. The storm or the wind caused an opening when the tree fell, and now there's water and you can't have service and you can't do tithes and offering. But with most churches, we found out as we looked at these policies that virus and pandemic were specifically excluded. So what we have learned is that you better take a good look at your policy. I've represented people in automobile accident under what's called uninsured motorist claims. That's when the negligent party did not have insurance, and the individual would tell me, well, Attorney Smith, I have $100,000 worth of coverage. No, you don't. The policy specifically says you only have $25,000. One of the worst areas that I see this problem in with churches and businesses is in the area of what's called actual cash value versus replacement cost. That's very, as a matter of fact, everyone, especially those that own businesses and real estate and things of that nature, you want to make sure that you have replacement costs, because replacement costs under your policy means that the insurance company has to replace what you have versus what you actually paid or what it actually costs to do it. So you got to read your policy. You have to, or call a lawyer and spend a couple $100 and ask that attorney to sit down and explain what's in that written document.
Now, when you say replacement value, is this something when they are applying for a policy that they can specifically ask for, or does it come in like a boilerplate style where they'll just put the value that you paid in there? Can you specifically request that in your policy?
You can request it. You can request it. Also, not only can you request it, you can also have a discussion regarding your policy limits. Keep in mind, an insurance policy is really nothing more than a contract. So you can contract for whatever that provision is. It's just like right now, some people think that they have flood insurance. And when your sewer backs up in your home, then you realize you may have flood insurance, but you don't have the coverage when there's a sewer back up and in your home. And those are two specifically different things. So I said that to say this: you can buy that, but the key is that you have to read your policy. There are boilerplate policies there, but I almost hate to use the word, but I'm thinking it, so I will. Most reputable insurance agents will give you what you ask for, but less is not always best. Think about that. It might cost you less, and I don't work for any insurance company. As a matter of fact, I've spent my life fighting with most of them. But sometimes trying to save a couple dollars on a premium on a monthly basis or whatever, get the extra coverage or protection that you need to make sure that you're made whole as much as possible.
What advice would you give, Pastor? I know you said that they need to read the policies. They may need to spend a little extra on the premium to have the type of coverage that they need. But this entire pandemic with COVID-19, what takeaways or lessons learned would you share with pastors to help them moving forward, that if the next breakout or pandemic occurs, what can they do now to protect themselves?
I think the areas, and some of it is from a legal perspective, and then some of it is from a pastoral perspective. From a legal perspective, I think the main thing that we want to do right now, I often suggest to pastors, make sure that your churches are as lawsuit possible as they can. Go back and read, what we just discussed a minute ago, your insurance policy. Not only read it, sit down with your agent. Don't just automatically accept a renewer, but make sure that when you renew that policy, that it says what you think that it says. One of the other areas that I often struggle, because I see pastors getting hit and church and ministry getting hit, is that there is a business side of ministry. I'm going to teach that one of these days. And when it comes to the business side of ministry, I've come to the conclusion that most of our churches and pastors are not successful. They're not successful because they're not good preachers. A lot of good preachers, a lot of good pastors. But when it comes to the business side of ministry, I thank God that before this pandemic hit, that we invested in upgrading the media equipment at our church with cameras and sound and things of that nature. So long story short, just prepare.
Okay, that's excellent. Everything I keep saying the same thing over. Excellent, good advice, because it is what you have to prepare for the storm before the storm hits, right? And so when this COVID-19 hit, so many people were not prepared. Businesses, the church, jobs, and individuals were not capable of working from home. There was no connectivity for a lot of the young people to study and to go to school from home. They were using the internet from parking lots and so forth. And I think one of the big takeaways from me is that look at what you have and how do you put business solutions in place to help you if something tragic or something unexpected happened to your business or to your church. So what can you put in place for that? And then the individual may say, well, I don't have any money to do that. If I had money to do that, I would not have been in a situation in the beginning. So for individuals that do not have money and do not have the ability to do some of the things you are discussing, what advice would you give that individual?
Preparation is still the key. If the resources are not there financially, meet with your people. Come up with a game plan on how to handle whatever the scenario. Have what we call in business a rapid response team. At National Temple, where I pastor, and the Missouri Gateway jurisdiction where I serve, and even in my law firm, I have key people that I can literally, not a whole lot, but I have key people that I can literally wake up in the middle of the night and bring those individuals together. Think in terms of a rapid response team. I can bring a group of intelligent people together at the Smith Law Firm at 2 a.m. in the morning. Hey, we've got to get this done, and it can't wait. The same way when it comes to churches and ministry, have those key people that, you can bring together, use them as a resource. No man, no woman is an island. If you're going to be successful in ministry, obviously you need God, you need Jesus, you need the Holy Ghost, the Bible, but you also need people. People are your precious resource. Have your key people and have a rapid response plan. And that's something that you can get together on a monthly basis, a quarterly basis, and have those key individuals in place ready to go.
Very good. Again, you are listening to Legal Views with attorney Sheila R. Stuart. We are coming to the end of our broadcast. That time went so fast. Attorney Smith, you did a phenomenal job, and we would love for you to come back. Can you share with us your last tips, your last information before we sign off. That individual that came on late, that's listening, what piece of information would you give that individual to help that person to become successful and effective?
The area where I see people hurting or not reaping the things that they're entitled to, whether it's in the legal world, the church world, is delay. You know, don't delay. Whatever needs to be done, don't wait. Delay is not your friend. You know, I once represented a pastor, and this is a combination where a legal and an ecclesiastical church matter met at the same time. I represented a pastor who, for whatever the reason, they had gotten behind with their taxes at the church, not paying their employees and doing those things. And the pastor knew that it was a problem, but every time he got the notice from the IRS, he put it in a desk drawer. He got a certified letter. He put it in a desk drawer. He just kept delaying, kept putting it off. And then one day, Attorney Stuart, as I was at my office, I received a call from the pastor. He was knocking on the door and said, Attorney Smith, the IRS is right here at my door. What do I do? Thanks be unto God, we were able to talk to the IRS agent and let them know that we were going to get the documents, get the information as soon as possible. They were very gracious and kind and said, Attorney Smith, we have been writing and calling. So whatever the legal problem might be, whatever the trouble might be at your church or in your life, don't delay. Let's jump on it today.
Okay, well, you heard it straight from the mouth of Attorney Bishop Melvin J. Smith. This is advice that we can all apply. I know I can apply it. Procrastination is not your friend. Do not delay. Take care of it today. Thank you, Bishop Smith, for being with us on today. Thank you, Donnie Savage, for this opportunity, and Daryl Breath, all the way in Boston, Massachusetts. Thank you for hosting Legal Views on C-Joy Network and 365 Live. Thank you so much. And now the mic is yours, Daryl Breath. The mic is yours. Thank you so much. And tune in next week. Next week is going to be a treat, the guest that we're going to present. Thank you so much.